The Fifth Circuit just dropped a legal bombshell, and most gun owners have no idea it even happened. In one sweeping ruling, 8 concealed carry restrictions were wiped off the books, and the media is acting like it never occurred. This decision fundamentally changes the landscape for millions of Americans who carry every single day. And if you don't understand what just happened, you could still be following rules that no longer exist. This is the kind of case that forces you to rethink your rights, how you carry, and what you can legally do without ending up in handcuffs. Before we get into it, here's something wild. More than 80% of people watching this video right now aren't subscribed. Don't be part of that statistic. If staying informed about your Second Amendment rights matters to you, hit the subscribe button and turn on notifications. What I'm about to explain could change how you carry starting today. So let's break down what actually happened. The case is called United States versus Rahimi, but what almost no one is talking about is the follow-up decision issued by the Fifth Circuit Court of Appeals in March. In that decision, the court closely examined 8 specific restrictions that states and federal agencies have been using for years to limit concealed carry permits. One by one, the court struck them down. And this wasn't a close call. The panel ruled decisively. The decision sent shockwaves through legal circles, yet the mainstream media barely acknowledged it. That silence alone should raise some serious questions. Here's the background. After the Supreme Court's 2022 ruling in New York State Rifle and Pistol Association versus Bruen, courts nationwide were forced to rethink how gun laws are evaluated. Bruen made one thing clear. Courts can no longer rely on interest balancing to uphold gun restrictions. Instead, the government must prove that any restriction aligns with the nation's historical tradition of firearm regulation. That changed everything. It was like the rules of the game were rewritten halfway through, and now every existing law has to justify its place on the field. The Fifth Circuit took that standard seriously. In March, they applied it to a collection of long-standing concealed carry rules. They examined where people are allowed to carry, who has the power to deny permits, what kind of training can be required, and how much discretion local officials can exercise. And the conclusion was clear. Most of these rules fail under the Bruen test. So let's walk through exactly what got dismantled. First up, subjective denial standards. This is the rule that allows a sheriff or police chief to deny your concealed carry permit simply because they don't like you. No clear criteria, no objective standard, just personal judgment. The Fifth Circuit ruled that unconstitutional. If the government is going to block you from exercising a constitutional right, it needs a legitimate, historically grounded reason, not a gut feeling. Giving a single official unchecked authority over a constitutional right is no different than letting someone decide whether you can vote based on their personal opinion. The court made it clear that doesn't pass constitutional scrutiny. Second, blanket bans on carrying in government buildings. This ruling does not mean you can walk into a courthouse armed tomorrow, but it does eliminate the sweeping rule that any building containing a government employee is automatically off limits. The court said the government must be precise. Sensitive locations like courtrooms and legislative chambers can still be protected, but declaring every DMV, post office, or administrative office a no-carry zone without historical justification doesn't work. If firearms weren't broadly banned from government buildings in 1791, the government needs a compelling historical reason to do it now. Let me pause here. Do you think this ruling goes far enough? Drop your thoughts in the comments, and while you're there, hit the like button. This kind of coverage doesn't happen on cable news, and your engagement keeps independent voices like AG Boring Finance alive. Third, mandatory live fire training requirements. Some states require applicants to attend classes, pass exams, and demonstrate shooting proficiency before receiving a permit. On the surface, that might sound reasonable. But the Fifth Circuit ruled there hosts no historical tradition of forcing citizens to prove skill before exercising a constitutional right. Imagine needing to pass a test before speaking publicly or practicing your religion. The court made it clear the Second Amendment operates the same way. The right exists first. The government cannot condition it on mandatory training. That doesn't mean training is bad. Responsible gun owners should absolutely know how to handle their firearms safely. But making training a legal prerequisite to exercising a right? Under this ruling, that's unconstitutional. Fourth on the list, prohibitions on carrying in places of worship. Several states had laws making it illegal to carry a firearm into a church, synagogue, or mosque unless explicit permission was granted by religious leadership. The Fifth Circuit ruled that these bans have no historical foundation. In fact, during the colonial era, Americans frequently brought firearms to church. Religious services were community gatherings, and in many areas, one of the few times large groups assembled in one place. Banning firearms in houses of worship is a modern concept, not a historically supported one. Because of that, it fails the Bruen test. If your state enforced such a rule, it now stands on extremely shaky legal ground. Fifth, bans on carrying in locations that serve alcohol. This one causes a lot of confusion. Many people mistakenly think it has something to do with drinking while carrying, which remains illegal in most states. But some laws went much further. They banned carrying entirely in any establishment that serves alcohol. Even if you weren't drinking at all, the court said that approach is far too broad. Taverns and inns were common gathering places in the 1700s, and there is no historical tradition of blanket bans on firearms in such locations. The government can prohibit carrying while intoxicated, but it cannot ban carrying simply because alcohol is present somewhere nearby. Sixth, residency requirements for concealed carry permits. Some states required applicants to live in the state for a set period before they could even apply for a permit. The Fifth Circuit ruled that unconstitutional. A constitutional right cannot be delayed based on how long you've lived somewhere. If you're a lawful resident, your Second Amendment rights are the same whether you've been there 6 months or 20 years. This is a major shift for people who move frequently, travel for work, or maintain residences in multiple states. Seventh, magazine capacity restrictions applied only to concealed carriers. Certain jurisdictions attempted to limit how many rounds a concealed carrier could have, even when the firearm and magazine were otherwise legal to own. The court rejected this logic outright. If a firearm and its magazine are legal, the government cannot arbitrarily impose separate limits just because someone is carrying concealed. The court emphasized that magazine restrictions are a separate legal issue. You cannot single out concealed carriers and treat them differently. Either the magazine is legal or it isn't. Eighth, and perhaps most important, vague good moral character requirements. Many permit applications include a question asking whether the applicant is of good moral character, without ever defining what that means. This gives officials enormous discretion. You could be denied because of a decade-old bar fight, a negative character letter, or simply because the official doesn't like your answers. The Fifth Circuit ruled that this kind of open-ended discretion is unconstitutional. If the government wants to deny a constitutional right, it must point to specific, disqualifying conduct, such as a felony conviction or a domestic violence offense. Subjective moral judgments are not enough. So what does all of this mean for you? If you live in the Fifth Circuit, which includes Texas, Louisiana, and Mississippi, these changes apply right now. These rulings are binding law in those states. But even if you don't live there, this decision is already being cited by courts across the country. This is the ripple effect of Bruen unfolding in real time. Every gun law is now under intense scrutiny, and judges are being forced to rely on historical evidence instead of assumptions about what sounds reasonable. Now let's talk about what happens next. First, states are going to appeal. They'll attempt to overturn or narrow these rulings. Some will request an en banc review, meaning the full Fifth Circuit would hear the case instead of just a 3-judge panel. That process could take months. Others will try a different approach. They'll rewrite their laws in ways they believe might survive the historical test. But here's the problem for them. The standard is now crystal clear. If a restriction cannot be tied to a similar law from the Founding era or the Reconstruction era, it's likely to fail in court. Second, expect a wave of new lawsuits. Gun rights organizations are paying very close attention to this decision, and they're already preparing challenges in other circuits. Cases are likely to appear in the Ninth Circuit, Second Circuit, and Fourth Circuit, targeting the same types of restrictions. Some of those courts are less friendly to gun rights, so the outcomes may differ. But that actually benefits gun owners in the long run. When circuit courts disagree, it creates a split, and circuit splits are exactly what draw the Supreme Court's attention. That's how nationwide rulings are made. Third, federal agencies will be forced to react. Agencies like the ATF have relied on some of these restrictions as part of their enforcement framework. With those tools removed, they'll need to adjust. That could mean new regulations, revised guidance memos, or different enforcement strategies designed to work around the ruling. You may also see Congress attempt to pass new legislation aimed at reinstating some of these restrictions in a form they believe is constitutional. But any such laws will be challenged immediately, and under the Bruen standard, most of them are going to face serious obstacles. Here's something I want to know from you. Which state do you think will challenge this ruling first? Drop your guess in the comments. And if this breakdown is useful to you, subscribe to AG Boring Finance so you don't miss what happens next. These legal battles move fast, and staying ahead matters. Now let's get practical. How does this affect your day-to-day life? Let's walk through 3 realistic scenarios. Scenario 1. You live in Texas and applied for a concealed carry permit last year. The sheriff denied your application because he said you didn't demonstrate sufficient need. You appealed, but nothing changed. Under this new ruling, that denial is unconstitutional. You now have grounds to reapply or challenge the decision in court, with Fifth Circuit precedent backing you up. That's a massive shift. Before, there was nothing you could do. Now, you have a path forward. Scenario 2, you're a Louisiana resident who prefers to carry while attending church. State law previously required written permission from religious leadership, and you never asked because you didn't want to create an uncomfortable situation. Under this ruling, that restriction is likely unenforceable. However, private property rules still apply. Churches, as private property owners, can set their own policies. The difference is that the state can no longer criminalize the act itself. That distinction matters. Scenario 3. You're moving from Mississippi to Texas. You want to apply for a concealed carry permit as soon as you arrive, but Texas previously enforced a 6-month residency requirement. Under this ruling, that requirement is unconstitutional. Once you establish residency, typically with a lease and a driver S license, you should be eligible to apply immediately. If you're denied, you now have legal precedent to challenge that decision. But here's the critical point. Just because a restriction has been struck down doesn't mean every local agency knows it yet. Some sheriffs and police departments are still operating under outdated rules. If you're denied or arrested under one of these invalid restrictions, you need to know your rights and be prepared to defend them. That means documenting everything. It means staying calm and not escalating the situation. And it means working with an attorney who understands Second Amendment law. The law may be on your side, but navigating the system still requires caution. Now let's clear up some common mistakes and myths, because there's a lot of confusion surrounding this ruling. Myth number 1, this decision means you can carry anywhere without a permit. That is completely false. The court struck down certain restrictions attached to permits, but it did not eliminate permit requirements in states that still have them. If your state requires a concealed carry permit, you must still apply and receive one. What changed is how much discretion the government has to deny permits and what conditions it can legally impose. The process still exists, but it must now respect constitutional boundaries. Myth number 2, you can now carry while drinking. Also false. This ruling addressed bans on carrying in places that serve alcohol, not carrying while intoxicated. Every state still prohibits carrying a firearm while under the influence. Those laws remain in full effect. What changed is this. You can legally enter a restaurant that serves alcohol while carrying as long as you remain sober. You can sit down, eat, and leave without fear of arrest simply because alcohol is present. But the moment you consume alcohol, you're crossing a legal line. Knowing that distinction is critical. Myth number 3, this ruling only matters if you live in the Fifth Circuit. That's not true. Court decisions influence each other. Attorneys in states like California and New York are already citing this ruling in their legal briefs. Judges across the country are reading it and weighing how it applies to their own cases. And if this case reaches the Supreme Court, it could become binding nationwide. Even if you don't live in Texas, Louisiana, or Mississippi, this ruling is shaping the future of gun rights across the country. Here's what many people are missing. This decision isn't just about concealed carry, it's about how courts will evaluate all gun laws moving forward. Waiting periods, feature bans, licensing schemes, everything must now survive the Bruen historical test. The government must prove that a restriction aligns with historical tradition, not that it sounds reasonable, not that it feels safer, but that it actually reflects how the Second Amendment was understood when it was adopted. That's a high bar, and many existing laws won't clear it. For decades, courts gave the government the benefit of the doubt. If a law appeared reasonable, it usually survived. Bruen reversed that approach. Now the burden is on the government, and when it fails to meet it, the law falls. This Fifth Circuit decision proves the new standard has real force. It's not symbolic, it's changing outcomes, and that matters. Let's bring everything together. The Fifth Circuit struck down 8 concealed carry restrictions, subjective permit denials, blanket bans, in government buildings, mandatory training requirements, prohibitions, in places of worship, broad alcohol proximity bans, residency requirements, magazine limits for concealed carriers, and vague moral character standards. That is a massive shift in how the law treats Second Amendment rights. It happened because judges demanded historical justification, not good intentions. And when the government couldn't provide it, the restrictions collapsed. Here's what you need to remember. First, know your rights. If you live in Texas, Louisiana, or Mississippi, these changes affect you right now. If you live elsewhere, they may affect you soon. Second, don't assume local authorities are fully informed. Some are, some aren't. If you face resistance, stay respectful, stay firm, and seek legal counsel when necessary. Third, this is just the beginning. More challenges are coming, more restrictions will fall, and the more informed and engaged people are, the stronger constitutional protections become. This matters not just for abstract legal theory, but for real people, real families, and the fundamental right to self-defense. That right is not a privilege granted by the government. It already belongs to you. We're not at the finish line yet. But decisions like this prove progress is being made, and that the fight is worth continuing. If you made it this far, you're serious about understanding your rights. Drop a comment and share your thoughts on this decision. The media may ignore it, but we won't. Stay armed, stay legal, stay informed.